Hello everyone and welcome back to your channel Lawpedia. This is me Jasmine, and in this particular video we'll be covering some of the important provisions of the Code of Criminal Procedure that deal with your bail aspect. So if you haven't watched the part 1 of this particular series, in which we covered section 436 and section 436A, essentially dealing with what? Dealing with bail in cases of bailable offences. I would highly recommend you to go and watch that video first and then come back to this one. So in this we'll be covering section 437 and section 439. There's a reason that we'll be covering section 438 in the next video. Starting today's video with this beautiful quote or write-up that was actually written by Shahid Bhagat Singh Ji in the jail notebook that he wrote. The quote goes like, "The sanctity of law can be maintained only so long as it is the expression of the will of the people." So with this, we start our today's video, and firstly, we'll be understanding that how we'll be covering section 437. So अगर आप section 437 पढ़ेंगे, that deals with bail in cases of non-bailable offences, the section itself is a 2-page section. So how will you remember it? You may understand it, but you will not remember or recall unless you break down the section into parts, and that's what I have done over here before understanding the section. So, firstly, understanding the main provision. The main section basically states when any person accused of or suspected of the commission of any non-bailable offence is arrested or detained without warrant. So, what's important that the person is suspected or accused of the commission of non-bailable offence, and such a person is arrested or detained without warrant by who? By an officer in charge of a police station, or appears or is brought before a court other than the High Court or the Court of Session. He may be released on bail. So now this is the main substantive portion of the section that you need to read for understanding the grant of bail in cases of non-bailable offences. Now the section 437 main part ends with a but. But means what are we considering? We are considering exceptions. So now there are certain exceptions that have been provided in the section itself. That means generally in cases of non-bailable offences, court may grant bail. However, there are certain exceptions. Jin cases may, if the criteria is fulfilled, the bail would not be granted in cases of non-bailable offences if these criteria are met. Firstly, which is the first exception? The first exception talks about such a person shall not be released on bail if there appears reasonable grounds for believing that he has been guilty of such offense punishable with death or imprisonment for life. So अगर कोई ऐसे circumstances लगते हैं केस में that it appears that there are reasonable grounds, the important term is reasonable ground, for believing that इस पर्टिकुलर पर्सन ने कोई ऐसा ऑफेंस किया है जिसकी पनिशमेंट डेथ या इम्प्रिजनमेंट ऑफ लाइफ हो सकती है, उन सिनेरियोज में कोर्ट में रिफ्यूज टू ग्रांट बेल. सो सेकेंड एक्सेप्शन इज सच पर्सन शिल नॉट be so released if such offense is a cognizable offense and he had been previously convicted of an offense punishable with death, imprisonment for life, or imprisonment for 7 years or more, or he had been previously convicted on 2 or more occasions of a non-bailable and cognizable offense. So now this states that अगर the offense committed by the person एक cognizable offense है and अगर वो same person पहले भी convict हो चुका है एक कोई ऐसे offense के लिए जिसकी punishment death या imprisonment for life है, उन cases में court bail grant नहीं करेंगे. If that particular person has been convicted of 2 or more occasions of a non-bailable and a cognizable offense. सो उन केसेस में भी बेल ग्रांट नहीं होगी. बेसिकली यहाँ पे ये है कि दैट इफ द पर्सन हु इज करंटली मे बी सस्पेक्टेड अक्यूज्ड ऑफ अ पर्टिकुलर ऑफेंस जो कि ऑलरेडी एक ग्रेव नेचर का ऑफेंस है, अगर पहले भी द पर्सन हैज कमिटेड एन ऑफेंस जिसकी पनिशमेंट इज एक्सटेंडिंग टू अ डेथ पेनल्टी और अ लाइफ इम्प्रिजनमेंट, हाउ कैन यू एक्सपेक्ट द कोर्ट टू ग्रांट बेल right now to the same person? Moving forward, we are moving forward in understanding when, despite such exceptions, the bail may be granted by the court. Court may direct that a person referred to in clause 1 and clause 2. What are clause 1 and 2? Clause 1 and 2 are these exceptions that we just understood. So despite the fact that person is in either clause 1 or either clause 2, that court may grant bail when such a person is under the age of 16 years or is a woman or is sick or infirm. Second one talks about court may also direct that a person referred to in clause 2 be released on bail if it is satisfied that it is just and proper to do so for any other special reason. So now you may observe jahan ki section tightens the grip and talks about that no, in such strict circumstances, in such grave nature of offenses, bail grant नहीं होगी. वहीं पे section एक relief देता है, वहीं पे section एक scope देता है for persons to improve, for them to actually understand that law upholds the liberty and freedom of an individual as much as it penalizes the acts of the individual. The section also states that the mere fact that an accused person may be required for being identified by the witnesses during the investigation shall not be sufficient ground for refusing to grant bail if he is otherwise entitled to be released on bail, and gives an undertaking that he shall comply with such directions as may be given by the court. Quickly moving forward and understanding our next aspect, which talks about conditions under section 437(3). Now ये दो parts में divided है because for you to understand better, I'll just explain. It would apply when a person is accused or suspected of the commission of an offense punishable with imprisonment which may extend to 7 years. The person is accused or suspected of the commission of offense under Chapter 6 against the state, Chapter 16 offenses affecting human body, and Chapter 17 offenses against property. So अगर ऐसे कोई offenses accused या suspected हैं तो उन cases में certain conditions may be imposed by the court. And thirdly, if the person is accused of the abetment, conspiracy or attempt to commit any such offense, and if such a person is released on bail under subsection 1. Subsection 1 is the main provision, main thing that we understood firstly in this particular video. So अगर ऐसा होता है, the person is accused or suspected of commission of these offenses and the person is released on bail under subsection 1, कोर्ट यहाँ पे कुछ कंडीशंस लगा सकते हैं. ये एक बहुत ही इंटरेस्टिंग मैकेनिज्म है टू बैलेंस आउट द फ्रीडम and to balance out the justice delivery and the penalizing aspect of our criminal law. So यहाँ पे कौन सी conditions हैं जो कोर्ट लगा सकते हैं? Court can impose conditions such as that the person shall attend the court in accordance with the conditions of the bond executed, वो regularly court में appear हों या जैसे भी जो भी provisions उनके bail bond में provided है वो properly execute हों. Secondly, court may also impose such a condition that such a person shall not commit an offense similar to the offense of which he is accused or suspected. ऐसा offense the person should not repeat, so that can be one of the conditions. The third aspect is the person should not make any inducement, threat or promise to any person acquainted with the facts of the case. So जो person है जो कि accused or suspected है, court ये कह सकता है that आप उन पर्सन्स को जो कि वेल अवेयर हैं विद द फैक्ट्स ऑफ द केस, आप उनको डराएं मत, आप उनको कोई इंड्यूसमेंट ना दें, कोई प्रॉमिस ना करें उनसे. प्लीज मेंटेन रेलेवेंट डिस्टेंस फ्रॉम देम बिकॉज दे आर वेल वर्स्ड विद द फैक्ट्स ऑफ द केस. दे माइट बिकम विटनेसेस इन द फ्यूचर, सो please maintain your distance unse. That can be one of the conditions of the bail. to be granted under section 437 subsection 1, and court may impose other conditions in the interest of justice. Moving forward and understanding certain case laws that I have mentioned for your better understanding, two case laws that I have referred. One is a 2018 Supreme Court judgment and another is 2005 Supreme Court judgment. One states that accused charged with serious offense by itself is not a ground to deny him bail if there are other circumstances justifying the grant of bail. So यहाँ पे सुप्रीम कोर्ट ने कहा है that अगर एक serious offense है, अगर other circumstances justify कर रहे हैं सिर्फ इसलिए कि that person has committed a serious offense, the person should not be denied bail. Of course, there are conditions that you may impose on the person so that the justice delivery mechanism is executed properly. Now next is a 2005 case which talks about successive applications of bail. So now बार बार जब जिन cases में application हो रही है bail की, उन cases में such applications must receive serious considerations at hands of the court entertaining the bail application at later stages when same had been rejected earlier. So now पहले किसी ने application दी, वो reject हो गई, फिर वो reject हो गई, now दोबारा आ रही है अगर court के पास, court में need to understand and we need to learn that why that particular application was rejected earlier. So now quickly moving forward to section 439. Section 439 grants special power to the High Court or the Court of Session in granting bail. So now what's the basic gist of section 439? If you read, subsection 1 has been divided into two components. First component talks about that High Court or Court of Session कोई भी पर्सन को जो कि एक ऑफेंस के लिए अक्यूज्ड है एंड इन कस्टडी है उसको रिलीज कर सकता है बेल पे if the offense is of the nature specified in subsection 3 of 437 and इसमें वो कुछ conditions भी impose कर सकते हैं as it deems necessary. Second part ये बात करता है that the High Court or the Court of Session direct कर सकता है that the conditions that are imposed by the magistrate उनको सेट असाइड कर सकता है या मॉडिफाई कर सकता है. सो लेट्स से मैजिस्ट्रेट ने कुछ कंडीशंस लगाई थी, हाई कोर्ट और कोर्ट ऑफ सेशन को ये पावर है कि वो उन कंडीशंस को मॉडिफाई कर सके या सेट असाइड कर सके. सो आई होप यू डिड अंडरस्टैंड सेक्शन 439 के बेसिक थिंग और द मेन प्रोविजन दैट इज ग्रांटिंग स्पेशल पावर्स टू हाई कोर्ट और सेशन कोर्ट टू ग्रांट बेल. मूविंग फॉरवर्ड, as per section 439 subsection 2, a high court or court of session may direct that any person who has been released on bail under chapter 33 be arrested. So यहाँ पे high court एक person की bail को actually cancel भी कर सकता है and उसको commit कर सकता है back to custody. The powers of the high court in granting bail are very wide. Even so, where the offence is non-bailable, various considerations will have to be taken into account before the bail is granted. Now, the Honorable Supreme Court has held that there are no restrictions on the High Court or Sessions Court to entertain an application for bail provided the accused is in custody. And that's it for today's video. And as we always say, please stay at home, stay safe and keep learning.